Blake Lively thought she had the perfect case. Motions were being granted, headlines made it look like she was untouchable. But in the shadows of the courtroom, Jed Wallace's legal team was quietly preparing a counterattack so devastating it could bring her entire lawsuit crashing down in one explosive move. Tonight, we're breaking down how her empire of claims may already be collapsing before our very eyes. Besties. The moment this story cracked open, it felt like Hollywood itself had been placed on trial, and what seemed at first like a straightforward tale of power and retaliation has spiraled into something that is almost unrecognizable, because the deeper you look, the more you see how fragile this case really is, and how carefully Jed Wallace and his legal team have been dismantling every sentence, every theory that Blake Lively has put forward. And what shocks so many is how different the surface looks, compared to what is happening behind the curtain on the surface. You have a star actress whose motions in discovery appear to be granted left and right, giving the impression that she is gathering strength and evidence to crush her opponents. But just because a judge grants discovery requests does not mean the plaintiff has the kind of evidence that can survive motions to dismiss or summary judgment. And that distinction is everything. Because while headlines shout that she is winning, her lawyers know that the battlefield is not the pretrial skirmishes, but the hard law that defines what counts as retaliation, what qualifies as harassment, and what stands as defamation. And it is in that arena where Wallace is wielding cold surgical precision, turning her grand narrative into fragments of contradictions and impossibilities. And the breathtaking part of it all is how methodical he has been, line by line, allegation by allegation, slicing away any illusion of strength and revealing how much of her case depends not on provable actions, but on theories, reputational harm, and speculation. And when you peel it back, you see the real heart of Wallace's argument that her claims against him are not employment violations, not retaliation, not harassment, but simply defamation in disguise. And that matters, because New York law has a defamation exception that bars plaintiffs from disguising reputational injury as something else in order to dodge the stricter requirements of defamation suits, such as the short statute of limitations, the obligation to identify specific false statements, and the towering burden of proving actual malice for public figures. And when you read his filings, the tone is almost icy, clinical, not theatrical, but relentless. He writes that her 2-paragraph attempt in a 31-page brief to overcome the defamation exception is hardly a response at all, and that silence speaks volumes, because if she cannot identify what was said when it was said or why it was false, then there is no case and no foundation. And as he builds this defense, you realize that his strategy is not only about clearing his own name, but about giving the blueprint for others like Wayfarer to dismantle her claims too. So what begins as Blake versus Wallace could end up collapsing her entire framework against everyone she accused, and it is here where the suspense builds. Because while she accuses Wallace of orchestrating a retaliation campaign, of spreading whispers that she was rude-tone, deaf, dismissive of domestic violence concerns, and while she tries to frame that backlash as deliberate sabotage, his team points out the obvious truth. Retaliation laws are not built for hypotheticals. They require concrete protected activity and adverse employment actions that follow. And she has neither. She describes speculation. She claims they wanted to preemptively silence her before she ever spoke publicly. But speculation does not equal retaliation. And when under oath she was pressed to identify a single article or statement Wallace made that harmed her, she admitted she could not name one, not one, and that admission lands like a thunderclap. Because for a case that hinges on a supposed media blitz aimed at destroying her reputation, the absence of any attributable statement is fatal, and Wallace's lawyer sees on that, repeating that her claims are nothing but defamation in disguise without the core elements that defamation law demands. And even more damning, they underscore how her reliance on California's Fair Employment and Housing Act collapses the moment jurisdiction is examined, because California law does not apply to non-residents who did not work in California and who did not experience discriminatory conduct there. And Blake herself admitted the harassment she complains of happened in New Jersey, not California. And then she filed in New York, trying to drag California law into the courtroom. And Wallace's attorneys tear that apart, pointing out that her own words concede the fatal flaw, and that courts have said again and again the FEHA does not apply outside of California, period. And the suspense only deepens because you see why she tried this maneuver. She forum shopped, she used California's Civil Rights Department to file a complaint, then switched to New York. because New York subpoenas allowed her to secretly obtain phone records evidence she could not have acquired under California's stricter notification laws. And while that may have seemed clever at the time, it has become the very rope tightening around her case because the contradictions pile up. She claims California law applies because invoices were paid from California companies, or because a decision may have been discussed there, but none of Wallace's alleged actions happened in California. The supposed media strategies, the statements, the planning, all occurred outside of California. And even more, Wallace denies doing them at all. And so even if California insiders made decisions, there is no allegation Wallace knew or joined, for retaliatory reasons. And without that knowledge, the aiding and abetting claims collapse instantly. And as Wallace's team keeps cutting through these arguments, they frame the entire narrative as reputational gamesmanship, not retaliation. They show that after claiming harassment, Blake did not withdraw or create distance. Instead, she demanded more involvement, more creative control, positioning herself closer to those she accused, and that choice undermines the very picture of harassment. She is painting and leaves jurors with a haunting question. Was this about safety, or was it about leverage and control? And that is why Wallace's filings feel so devastating, because they are not written as counterattacks. They read as demolition. Orders, each section tearing down a pillar until the structure cannot stand the emotional weight of it hits you, as you realize that the discovery victories making headlines are distractions from the legal earthquake, quietly building under her feet. And if the judge embraces even one of Wallace's clean surgical arguments, the entire case could fall apart in an instant. And that is why many are starting to whisper, not about whether she can win, but about how quickly her own case may be thrown out, leaving her standing in a courtroom with nothing but fragments of accusations and a blueprint that has already been weaponized against her. The unraveling of Blake's case grows even more dramatic when you focus on how Jed Wallace's attorneys expose the contradictions buried within her retaliation theory, because at first glance it sounds explosive that she accuses Wallace and others of launching a coordinated campaign to destroy her reputation before she ever went public with harassment claims. But when you examine the mechanics of retaliation law, the holes gape open wide. Retaliation requires a protected activity, something like filing a complaint with HR, testifying in an investigation, or speaking out publicly, followed by an adverse employment action like termination, demotion, pay cuts, or hostile work conditions. Yet Blake's narrative hinges on the idea that people retaliated against her, preemptively trying to ruin her reputation before she acted. And Wallace's team rightly points out that the law is not built on hypotheticals or preemptive silencing. It is built on tangible sequences, action, and reaction. And in her own sworn deposition, she admitted she never filed an HR complaint. She never documented harassment through official channels. She never even pinpointed a single act Wallace himself carried out to harm her. And that admission is devastating, because while the courtroom drama makes headlines about smear campaigns, the cold precision of law reduces it to nothing more than conjecture. And the more you think about it, the more suspense builds, because it paints a picture of a case built on shadows and echoes, not on evidence. And Wallace's lawyers push that image further by showing how Blake repeatedly ties every harm back to reputational injury, framing it as damage to her image, her credibility, her standing in the industry, and that is exactly why they argue this belongs in defamation law, not in employment law. And New York's defamation exception slams the door on trying to disguise those claims under other legal labels. And if the judge agrees that reclassification alone guts her case, it means all the motions, all the discovery, all the media storm boils down to a technical but decisive legal kill shot. And the irony is painful, because Blake's legal team may have believed that broad emotional framing would strengthen her position, but in reality, it gave Wallace the very ammunition to collapse her arguments by using her own language against her. Because when she says smear campaign and reputational harm, she confirms that it is about defamation, and for a public figure, defamation is one of the hardest claims to prove, requiring not just proof of falsity, but proof of actual malice, that the statement was knowingly false or made with reckless disregard for the truth, and without identifying a single statement, let alone proving malice. Her case evaporates in the New York courtroom, and yet the suspense deepens because she tried to anchor her claims in California's FEHA, and on paper, that looked like a lifeline, stronger employee protections, broader retaliation standards. But her reliance on California law collapsed the moment jurisdiction was examined, because she admitted the conduct occurred in New Jersey, then dragged the case into New York while trying to apply California statutes. And Wallace's team shredded that maneuver, showing that California courts themselves have made it clear again and again, if you are not a California resident, not working there, and not harmed there, FEHA does not apply, period. It does not matter that a company paying invoices is based in California. It does not matter that lawyers coordinating the defense might sit in California. What matters is where the alleged misconduct occurred, and none of it ties Wallace personally to California. So when she argues that California law should apply because a California company was involved, it feels clever on paper, but collapses under scrutiny, and his attorneys drive the knife deeper, pointing out that even if Wayfarer or other entities made decisions in California, there is no allegation Wallace himself knew of or joined discriminatory acts for retaliatory reasons, which is the heart of aiding and abetting claims. And without that link, the law provides no traction. Her claim dies. On the vine and suspense builds because the same argument can be replicated by Wayfarer and others when they file for summary judgment, leaving Blake isolated watching her allies' defenses strengthened by the very filings designed to remove Wallace. And that is where you feel the emotional weight of the strategy, because it is not just defense, it is blueprint demolition, dismantling the entire architecture of her claims with surgical precision paragraph by paragraph. And in the courtroom, the atmosphere must feel electric with tension as her attorneys try to defend expansive, sweeping theories, while Wallace's side responds with concise, targeted scalpel-like arguments that the judge can digest easily and efficiently. And that contrast matters because judges are human. They have limited patience for sprawling 31-page briefs that only devote 2 paragraphs to the central defamation problem, while Wallace's team slices through point after point with brutal clarity. And in litigation, clarity often wins more than volume. And if you imagine the judge reading through these filings, you can almost see the reaction, the frustration at evasive responses, the appreciation for precise legal reasoning, and the weight of that. Perception cannot be underestimated, and the contradictions in Blake's story add even more suspense because she describes harassment that supposedly made her unsafe. Yet instead of distancing herself, she fought for more creative control on the film, embedding herself deeper with those she accused. And that choice will not be lost on a jury if it gets that far. Because jurors are everyday people, and everyday people know that when you are harmed, you seek distance, not proximity. So when she demanded more control, more closeness, more power, it raises the chilling possibility that these claims were not about safety, but about leverage and control over the project. And Wallace's team subtly presses that implication without ever needing to accuse. They simply lay out the facts and allow the contradiction to speak for itself. And in a trial setting, those contradictions can poison credibility faster than any external criticism. Because once a jury senses manipulation or gamesmanship, the emotional connection fractures, and without credibility, even the most dramatic allegations cannot carry weight. And that is why the suspense grows heavier with every filing. Because Wallace is not playing theatrics, he is writing with clinical detachment, letting her own contradictions do the heavy lifting. And the result is filings that feel less like defense briefs and more like demolition manuals, slowly tearing down the structure until there is nothing left standing. And the chilling part is that the judge now has multiple clean avenues to dismiss the case, whether it is the defamation exception, the lack of jurisdiction, the failure to plead retaliation properly, or the contradictions in her own sworn testimony. And Wallace's team is making sure the judge has all those exits lit brightly and ready to use. And when you step back and see the broader picture, you realize that this case, which once looked like a crusade for justice, may instead become a cautionary tale about overreach, about forum shopping, about the dangers of stretching narratives beyond the law's capacity. And if it collapses, it will not be with a bang of scandalous revelations, but with the cold thud of legal precision stripping every claim to nothing until only silence remains. And that suspense, the waiting for the judge's ruling, is almost more dramatic than any revelation could ever be. The part that truly twists this entire saga into something larger than one case is how the courts are now being forced to grapple not just with the technical boundaries of defamation versus retaliation, but with the performative power of celebrity in shaping public perception. Because while Blake Lively tries to use her fame as both shield and sword, the legal system does not bend to charisma or red carpet glow. And what Wallace and his team have done so brilliantly is strip the glamour away. Until the filings read not like the chronicles of a beloved actress fighting for justice, but like the paper trail of a litigant with no evidence straining to survive procedural slaughter. And the effect is eerie because you feel the silence in her briefs where citations should be. You see the vacuum where facts should live, and it becomes undeniable that this is not about law. This is about narrative control. And when that illusion cracks, the fallout spreads beyond her, into the very institutions. She dragged into the fight, for example, her insistence that California law applied forced the Civil Rights Department into a strange position of entertaining a complaint that now looks retroactively baseless, and already lawyers are whispering about whether this will expose the department to criticism for acting outside its scope. And then there is the subpoena issue because Blake's team used New York's broad powers to quietly dig into phone records without notice to the targets. A move that, while technically legal, reeks of ambush tactics, and now Wallace's filings spotlight those tactics, daring the court to acknowledge the manipulation. And if the judge even hints at disapproval, the reputational cost to Blake could outweigh anything she feared from Wallace's supposed whispers, and it is in this tightrope act that the suspense lives. Because every step she took to expand her reach, to increase her leverage, is being reinterpreted as overreach, as desperation, as evidence of a strategy built not on facts, but on force of will. And that is where the danger lies for her. Because courts are not arenas for branding exercises. They are merciless machines that grind down narratives into statutory elements and evidentiary proof. And when the proof is not there, no amount of star power can fill the void, and you can almost feel Wallace's lawyers leaning into that truth, writing with a kind of cold patience that dares her to keep talking, knowing the more she speaks, the more contradictions appear, and one of the most haunting contradictions comes from her claim of retaliation itself. She argues that Wallace spread reputational harm to preemptively silence her before she engaged in protected activity, but by definition, retaliation requires protected activity to precede adverse action. Otherwise, it is not retaliation, it is speculation. And when pressed, she conceded that she had not yet engaged in public protected activity before the supposed retaliation began, and so the claim collapses on its own timeline, and Wallace seizes on that temporal flaw, pointing out that her case rewrites cause and effect into a self-serving fantasy. And once a court acknowledges that flaw, it cannot be unseen, and then you realize that if retaliation dies, the rest of her claims tumble with it, because harassment, aiding, and abetting all rely on the same shaky premise. And Wallace even dismantles her attempt to invoke New York human rights statutes by highlighting how they require more than generalized workplace tension. They require targeted conduct tied to protected categories, and she has none. And when you add in her own deposition, where she admits she cannot recall a single direct statement Wallace made against her, the silence becomes deafening. And that silence is now louder than any accusation, because in court, silence is proof that nothing exists. Proof that the story was never rooted in fact. And while her PR allies spin narratives outside the courtroom, inside the filings, her case is disintegrating line by line, and the suspense grows, not only because of what is happening to her, but because of what it means for Hollywood lawsuits more broadly, because this case is now a warning that discovery wins do not guarantee trial, wins that media sympathy does not equal admissible evidence, and that forum shopping is a double-edged sword, because if you manipulate jurisdictions too openly, you invite judicial backlash and perhaps sanctions. And Wallace's filings all but beg the court to make an example of this case, to say publicly that celebrity does not rewrite statutes, and that reputational gamesmanship does not create causes of action. And if that happens, the ripple effects will be seismic. Content creators who have already received subpoenas will point to Wallace's blueprint to challenge them. Networks who fear being dragged in will breathe easier. And lawyers who once thought Blake's case was a template may now see it as a cautionary tale of overreach, hubris, and collapse. And what chills you most is that all of this is happening quietly in motions and memoranda, far away from cameras. But the moment a ruling drops, the silence will end. And the narrative she fought so hard to control will no longer belong to her. It will belong to the court and to the public, who will see in black and white that the great Hollywood retaliation drama was never retaliation at all, but defamation in disguise, without the evidence or the law to sustain it. What makes this unfolding story almost unbearable to watch is the way Blake's carefully curated image of strength and certainty keeps colliding with the hard edges of the legal process, because the more her team tries to expand the narrative into sweeping claims about harassment, retaliation, and reputational sabotage, the more the court drags it back into the narrow technical confines of the law. And that narrowing has become the silent killer of her case, because when you strip away the emotional framing, the press tours, and the suggestion that she was the target of a sophisticated campaign of silencing, you are left with nothing but the statutes and the evidence, and those do not bend, they do not flatter, they do not sympathize. They only measure, and the measurements are brutal for her case. Wallace's lawyers point out again and again that to survive, she must show protected activity that triggered retaliation. She must show adverse employment action, and she must connect those dots with evidence, but she has none. And it is devastating to realize how quickly the momentum shifts once you see that her entire case rests on the idea that reputational criticism itself equals retaliation. And that assumption simply does not survive judicial scrutiny, because criticism in the press, even sharp criticism, is not an adverse employment action under the law. And even worse, she cannot pin that criticism on Wallace himself, because when asked directly, she admitted she could not identify a single article or quote directly tied to him, not one. And yet her whole theory of the case rests on him as the architect of her downfall. So when Wallace dismantles that link, the dominoes fall in every direction, and what looked at first like an intricate conspiracy unravels into scattered coincidences and media chatter that no court will ever call retaliation. And then comes the jurisdiction trap she set for herself, because by filing through California's civil rights department, she opened a door that she now desperately wants to close. But Wallace locks it behind her, pointing out that California's FEHA statute has nothing to say about conduct that happened entirely in New Jersey and New York, and that by her own testimony, none of the alleged harassment occurred in California. And once that contradiction is exposed, the entire California legal hook she depended on collapses, leaving her stranded in a New York courtroom where New York law does not recognize the sweeping theories she wants to pursue. And it becomes clear why she tried so hard to forum shop, because she knew New York law would not give her the breathing room she needed. So she reached into California, hoping to expand her rights. But Wallace's filings slash that hope apart, showing that you cannot expand a statute beyond its boundaries simply because you are famous. And the irony is suffocating, because the very fame that gave her the power to shop forums and gather subpoenas is the same fame that now magnifies the collapse of those maneuvers into a public humiliation. Because as soon as the judge echoes Wallace's logic, the press will not frame it as a technical legal correction. They will frame it as a celebrity, caught bending the rules and losing. And that perception is more poisonous than any statement Wallace allegedly made, because it reframes her not as victim, but as aggressor, overreacher, manipulator. And courts are merciless when they sense manipulation. And so the suspense grows sharper with each filing, because Wallace's arguments are not just aimed at dismissal, they are building a narrative of their own, a narrative of a plaintiff who twisted jurisdictions, who disguised defamation as retaliation, who admitted under oath that she could not tie her accusations to any verifiable statements, and who used her fame as leverage rather than fact as evidence. And that is why observers now whisper that this case may end not with a quiet settlement, but with a devastating judicial order that strips away her claims entirely and sets precedent for future celebrity cases. And if that happens, the echoes will stretch across Hollywood, because other stars who thought they could litigate reputational grievances under the cover of harassment or retaliation statutes will see that door slam shut. And that realization could be career-ending for Blake, because Hollywood thrives on illusion. And once the illusion cracks that you are untouchable, that you are legally invincible, the industry recalibrates overnight, the studios pull back the endorsements, dry up, the allies scatter, and all that remains is the paper trail of a lawsuit that promised fireworks, but delivered only silence and failure. And that is the terrifying cliff edge she now stands on, with Wallace patiently pushing her closer step by step, knowing that one ruling could send her entire case tumbling into the void. Blake Lively entered this legal fight believing she had built the perfect case, but the courtroom is revealing a very different story. The motions that once looked like victories are now being exposed as surface-level wins that may not hold up when the law is applied in full. Jed Wallace's legal team has strategically shifted the focus, showing the judge how her retaliation claims are rooted in speculation, how her reliance on California law fails in a New York courtroom, and how her own sworn testimony undermines the very foundation of her arguments. Piece by piece, the walls of her lawsuit are crumbling, and the strength of her case is evaporating in real time. The defamation exception in New York law is proving to be her biggest obstacle, one that she cannot sidestep with clever framing or creative labels. Every attempt to repackage reputational harm as retaliation falls apart under legal scrutiny, leaving her exposed to the reality that this may never reach a jury. Add to that the devastating admission that she cannot identify even one harmful statement made by Wallace, and suddenly the entire narrative shifts from power to collapse. What began as a confident strike against her critics now looks like a legal storm consuming her own credibility. So where does that leave Blake Lively? With headlines swirling, Hollywood whispering, and the courtroom tightening around her? The future of this case looks uncertain at best. If Wallace succeeds in dismantling her claims, other defendants will almost certainly follow with the same blueprint. What was meant to be a weapon of reputation may now become her greatest liability. And as the judge weighs these arguments, one truth becomes clear. This is no longer about Blake Lively controlling the narrative. This is about whether her story can even survive the courtroom.